Hello, everybody. It is Jay here with Law, Liberty, and Logic, and this is the first ever live stream that I've done on this channel. For many years, I've just kind of done little videos explaining some basic concepts in law and help people navigate those ideas, get some background education information so that they can take that and then work with a lawyer and get some resolution. So I'm excited to test this out, this first time here. And if you haven't ever been to the channel before, maybe this is populating to you for the first time, make sure to subscribe to the channel today, Law, Liberty, Logic. Make sure you get that notification bell so that you can see the next time I do this. Because again, this is all novel and it's something that has never been done before here on this channel. So I'm excited to pilot it and see how it goes. So as you can see from the description and the thumbnail, I'm just going to talk about the basics of resisting in a nonviolent way an unlawful arrest. So this is very narrow. This is not, talking about someone who's resisting an arrest where it's lawful. This is not talking about a violent resistance where you're fighting someone, hitting someone, that kind of thing. So when we talk about nonviolent resisting arrest, especially when it's an unlawful arrest, we're just usually talking about someone using words and, basically protesting that they're being arrested. So I'm going to go ahead and pull up that case here that kind of springs this discussion. It's JV State, and this was a decision that was, taking place April 14th, 1999. It is in the state of Florida because, we do have a Florida focus here, and it's the Florida District Court of Appeals, specifically here for the 4th District. So as always, when it comes to, Florida law in different districts, this district is an appellate district, so it's not the Florida Supreme Court. So the ruling here does technically apply only to that region, but the information here and the things that are cited to come together and really help explore this topic. So I'm going to read through this case and one other case just to give you a sense of it, and maybe that helps educate you and enlighten you on what it is that it means to have a nonviolent resisting of an unlawful arrest. So in this case, it was a public defender situation. It says Richard L. Jordanby, public defender, and Sophia Letts, assistant public defender in West Palm Beach. They're going up against the attorney general in Tallahassee, who's Robert A. Butterworth. And we're just going to focus here on the case details and talk a little about it. So it says Tyrone J. appeals his convictions for resisting an officer without violence and possession of a weapon by a convicted felon. It says that the court reverses. The arresting officer testified that while on a sting operation, he was attempting to solicit 2 females, one known to him as a prostitute, when Jay told the females, "Don't get in the car, he's a cop." Okay, again, that's just showing that there's words. So that's an interesting note here that at this point, it's just words. The 2 females walked away and were never arrested. The officer, having perceived Jay's comment as obstructing him in the execution of his legal duty, told Jay that he was under arrest, but Jay immediately fled. When the officer caught Jay, the officer discovered a knife in Jay's possession. Jay was subsequently arrested and charged with resisting an officer without violence and possession of a weapon by a convicted felon. So as you can see here, at the onset, the officers just had words alone. There wasn't any violence. All he had was his words, and then running away after, of course, he was saying that he was being arrested. And the officer then, of course, was just dealing with that charge, resisting an officer without violence, which normally happens when they have a lawful duty to arrest. But in this case, we got to see what those facts pan out with. And of course, this is a possession of a weapon by a convicted felon. So that's a separate charge, right? But again, when it comes to criminal things, you can only get to that point of actually having that evidence come in if the procedure by which it was brought in was lawful. So that is an issue that happens sometimes. Sometimes the evidence gets taken out, motion limited, or dismissed because the evidence that was procured was done unlawfully. So the resisting charge was based upon Jay's flight from the officer's attempted arrest for the uncharged offense of obstruction. Following the denial of Jay's motion to suppress, Jay pled nullo contendere and was adjudicated guilty, declared a habitual offender, and sentenced to 19 months in prison. So that's pretty hefty. Jay asserts his comment did not obstruct the officer in executing his legal duty, so the attempted arrest for obstruction was unlawful, and therefore he was free to resist the arrest without violence. Moreover, he maintains the resulting weapon charge cannot stand because the arrest for resistance without violence was illegal. The court says we agree. An essential element of resisting an officer without violence that the arrest is lawful, right? So to have a charge where you have resisting without violence, that arrest has to first and foremost be lawful. Otherwise, then police can just arrest you unlawfully, and then you're like, hey, no, stop. This is wrong. And they're like, oh, and we're going to charge you with something else, even though what it was originally was unlawful, right? It'd be ridiculous. So if an arrest is not lawful, then a defendant cannot be guilty of resisting it. And so this is citing another case here, this, TMM, because I think it might be a minor. So a lot of these cases, sometimes will be with minors where these nuanced issues come out and, they just abbreviate their names because they don't disclose that to protect privacy. So, and then that was citing Dean v. State, another 4th District Court appeal decision. The common law rule still remains that a person may lawfully resist an illegal arrest without using any force or violence. And again, another citation to the Florida 1st District Court of Appeal, a 1990 case. They also have a 5th District. They also have another 4th District case. So multiple different jurisdictions agreeing with this. Although Jay was not charged with obstructing the officer, the state maintains that the attempted arrest for obstruction created the basis for the resisting arrest charge. The attempted arrest of Jay was based upon Florida statute section 843.02, resisting an officer without violence, which provides whoever shall resist, obstruct, or oppose an officer in the lawful execution of a legal duty. So in other words, they're trying to say, well, you were obstructing us otherwise, so we could arrest you. Because the law permits a person to resist an illegal arrest without violence, Jay committed the crime of resisting an officer without violence only if the underlying attempted arrest for obstruction was lawful, right? So they had to first say, okay, well, was the obstruction lawful? As in, the obstruction charge was lawful, not that the obstruction was lawful. To support a conviction under section 843.02, the state must show, 1, the officer was engaged in the lawful execution of a legal duty, and 2, the action by the defendant constituted obstruction or resistance to that lawful duty. And they're citing here to the 1st District Court of Appeals. Thus, for the initial arrest to be legal, the officer's involvement in the sting operation must have been the performance of legal duty. And Jay's words, don't get into the car, he's a cop, must have obstructed the officer in executing his legal duty. On the question of whether officer was performing legal duty, it's important to distinguish a police officer in the lawful execution of any legal duty and a police officer who is merely on the job. Defendant's verbal protest and refusal to answer police questions during a search for robbery suspect was held not an obstruction of justice, for example. Further, the court provides 3 legal duties when coupled with words alone, which will result in obstruction of justice. 1, serving process. 2, legally detaining a person. Or 3, asking for assistance. The facts of the present case, however, do not fall within any of these 3 categories, and as such, we must decide the officer's sting operation was the execution of a legal duty or if he was merely on the job. In Porter v. State, officers, while on surveillance, observed drug deals taking place and began to approach the scene to take the dealers by surprise and arrest them. As the officers approached, Porter, the lookout, yelled, "Plain clothes," to alert the suspected drug dealers of the officer's presence, thereby allowing the dealers to escape apprehension. We upheld the conviction of Porter for obstructing and interfering because he concluded his words interfere with the police in the execution of the legal duty of arresting suspects by preventing their apprehension. However, the present case is clearly distinguishable. In Porter, the police officers had observed drug dealings taking place and were preparing to arrest the suspected dealers. So again, big difference here. The police already had their probable cause to make an arrest. Here, the police didn't actually have anything. They were investigating, but they didn't actually have any probable cause to actually arrest anybody whatsoever. Not even a reasonable suspicion to even detain someone at that point. As such, this court concluded that Porter's words were intended to impede the officers in the execution of their duties, i.e. Porter's words warned the suspects, allowing them to escape apprehension. Furthermore, the duty in Porter attempting to legally detain the suspects is a duty which falls within one of the 3 categories. Whereas here, there's no evidence that the 2 targeted women had committed any crime from which they escaped apprehension. The 2 women simply walked away, were never arrested. In State v. Dennis, during a drug sale, 2 officers waited out of sight for the undercover officer's cue to move in and arrest the dealers. The defendant saw the 2 officers waiting in an unmarked car and yelled 99, a street term meaning police were in the area. The court concluded that Dennis's words did not obstruct justice because he was not involved, nor did he have any knowledge of the criminal activity, unlike Porter. And that's very interesting, right? The knowledge of criminal activity versus just, oh, there's cops here. That's not necessarily obstructing if you don't particularly know anything. However, it can be inferred from Dennis that the court reached the preliminary conclusion that the officers were engaged in the execution of a legal duty because absent the execution of legal duty by the officer, the court's discussion of the effect of Dennis's conduct and the conclusion that his words did not constitute obstruction was unnecessary. Though in Dennis, the officers were not yet moving in to make an arrest, the cases are similar in that criminal activity was actually taking place, i.e. the drug sale was occurring. So again, just pointing out there's actual criminal activity taking place. In the present case, while the officer was attempting to solicit from the two females, there is no evidence that the two women agreed to anything illegal before walking away. Thus, unlike the situation Porter and Dennis, there's no criminal activity occurring at the time Jay told the women, "Don't get in the car. He's a cop." Further, there is no evidence that the officer was detaining the two women or even attempting to detain them for a crime they committed, as was the case in Porter. As such, we conclude the officer in this case was merely on the job and not engaged in the lawful execution of any legal duty. Because we conclude the officer was not engaged in the lawful execution of legal duty, we need not address the second element, whether Jay's conduct constituted obstruction of a lawful duty. Accordingly, the attempted arrest for obstruction was illegal, and Jay was free to resist such an arrest without violence. The remaining charge, possession of a weapon by a convicted felon, was based upon the officer's discovery of a knife during the unjustified pursuit following the attempted illegal arrest of Jay. Because the arrest for resisting was illegal, the evidence of the knife discovered during the attempted illegal arrest should be suppressed under the fruit of the poisonous tree doctrine. In sum, we conclude Jay's words did not obstruct the officer while he was executing his legal duty, and thus the officer's attempted arrest for obstruction was unlawful. Absent a lawful arrest for obstruction, Jay was free to resist such an arrest without violence. Moreover, the knife found as a result of the illegal arrest for resisting should have been excluded. Accordingly, we reverse Jay's convictions and remand to the trial court. So the main things to point out here is that if you notice in the language, it's very specific. There is absolutely no way for an officer to say that you're committing a crime just because you verbally say, "Hey, I don't want to deal with you," or "What are you doing?" or this or that, right? Words alone is not violence. And if the officer has no particular reasonable suspicion that you are about to commit a crime, they don't have a probable cause, to say that, okay, we can arrest you. Well, then it's just words. So you can't sit there and say, "Well, I get to arrest you because I don't like your words," right? That's First Amendment protected, and it's not violence to just say words. It's a good question here too. If they would address the running aspect. I mean, at least the running away, at least how they presented it, seems like running away is not itself violence. So even running away from an unlawful arrest, again, doesn't seem to appear in this case as an act of violence. And why would it? He's not hitting the officer. He's not doing anything, violative of the officer's physical body or property. He's not making any threats. So just running away, especially if it's an unlawful arrest, is just nonviolent. So from this case, we kind of have a sense that if you're resisting an arrest that is unlawful, words alone, okay, that's nonviolent. That's totally fine. And running away, nonviolent. So those are two key things that if someone were to be in that situation where an officer says, "I don't like what you say," and they arrest you, but there's no reasonable suspicion, no probable cause, the officer could be in legal hot water. Or if somebody runs away from an officer who's trying to conduct an unlawful arrest, well, that running away is not considered violence in and of itself. So it's a very important distinction to make. And for some people, that is going to be a big deal. It's going to be the difference between possibly, being in legal hot water or possibly having a lawsuit potential against officers for violating their rights. So I want to talk about one other case I think really highlights these ideas. And that case here is CWV State. So this is a later case. This is from December 28th, 2011. And in this case, there is a juvenile appellant. And of course, when it comes to juveniles, they're going to have their initials. They don't say their full names because they want to protect their privacy. But a lot of cases that come up in these edge cases and appeals often deal with young people. There's a lot of times where young people are especially targeted and their rights are violated because police can think they can get away with it, because, they're just a kid, so I can push the envelope. But eventually it does come back to bite them in the butt if they sue over their rights being violated. So, all right. In this case, it is a 3rd District Court of Appeal of Florida where this case took place. So it's another public defender situation, very common in these kinds of things. A lot of criminal appeals deal with public defenders. And it happens to be Pamela Jo Bondi, Attorney General, who was one of Trump's cabinet picks of late. We'll see if she gets confirmed. But she was a big gun grabber in Florida, very bad on gun rights. So seeing her lose would be nice. All right, let's take a look here. It says CW, a juvenile, appeals from an order denying his motion for judgment of dismissal and adjudication delinquency. We reverse and remand with instructions to discharge the adjudication delinquency. In other words, they're not delinquent. They did not violate the law. CW was initially charged with disorderly conduct and resisting arrest without violence. The underlying basis for the arrest was the alleged disorderly conduct, which in turn arose from an uncharged violation of Section 316.2045 of the Florida Statutes by 10, a pedestrian infraction for obstructing traffic. The uncharged traffic obstruction offense was premised upon appellant's act of standing in the road a couple of feet from the swale and refusing to move off the street when the officer asked him to, although the record also shows that there was no traffic in the street at the time. The record does reveal that CW was talking to another boy, his cousin, when they saw a police car slowly approaching. The officers veered slightly around the kids and asked them to move out of the roadway. When they did not, the officers parked, approached the boys, and ordered them to move out of the road and onto the unpaved swale. At this point, the record shows that CW refused to step out of the street and use profanity, right? So again, not physical violence, just profanity, but profanity is still free speech. So the officers then arrested him. The record does not show that CW was ever given a citation for the pedestrian violation, and it is not cited as a basis for the arrest. The petition for delinquency only states that CW failed to follow the order of said officer to get out of the street where traffic was moving. Although he was arrested for disorderly conduct, neither the record nor the petition for delinquency show that CW was prosecuted for disorderly conduct. The only charge for which appellant was adjudicated delinquent was a charge of resisting an officer without violence in violation of Section 843.02. So important thing to note here, especially, is that you could be charged for a crime, but if they don't follow through on prosecution, then you don't actually have that predicate, charge. They're saying, oh, okay, anything that comes after is a legal duty, that you were actually properly charged and move forward on that before going to saying, well, and you were resisting, right? If they didn't follow through, the officer makes the arrest, but it's up to the prosecutor to follow through on the actual charge. So with that information, so it seems like someone dropped the ball there. To convict a defendant of obstructing or resisting an officer without violence, the state must prove two elements. The officer was engaged in the lawful execution of legal duty, and two, the defendant's action constituted obstruction or resistance of that lawful duty. And this is citing a lot of the same cases, that we were just talking about before. They had the Florida 4th District Court Appeal case here with JPV State and JV State, which we just talked about from 1999. It says the state fails to sustain either element. The evidence does not support a conclusion that the officers were engaged in the lawful execution of a legal duty with their initial request that CW step out of the street. The case law provides that legal duties include serving process, legally detaining a person, or 3, asking for assistance in an emergency situation. Oh, and they add one here, or 4, impeding officers' undercover activities by acting as a lookout during the commission of a criminal act. So that one was left off in the 99 case, but they specifically articulate that. Even though in the 99 case with Jay, they did mention that, kind of in the cases themselves when they were distinguishing, but here they actually kind of make it one of the explicit situations. They talk about Davis v. State again. Although this is not an exhaustive list, it is clear that there's a difference between an officer who is engaging in the lawful execution of legal duty and a police officer who is merely on the job. The officer's initial request that CW move a de minimis distance out of the road was a reasonable part of their job as community safety officers, but the officers had no legal duty to insist on compliance and to enforce that insistence with arrest, where the records show that there were no circumstances warranting this. And they cite to the 4th District Court Appeal again, 2009. So they say holding that there was no evidence of trespass sufficient to sustain a charge of resisting arrest. So again, they were standing in the street. There was probably no cars. It might have just been on the edge, and there was no reason to go after them, apparently. Here, there is no evidence that CW actually interfered with traffic, and the mere potential to interfere with traffic is insufficient to justify the officer's actions. So they cite to another case here, Underwood v. State in the 4th District Court Appeal, holding that an officer lacked probable cause to stop the defendant for obstruction of traffic because there was no evidence that the defendant actually hindered or endangered the normal use of the street or had intent to do so. Moreover, in evaluating a citizen's verbal response to a police officer, it is understandable that a police officer in good faith may see an obstruction where another citizen sees an appropriate protest. Right? You can protest police. You have a First Amendment right to protest. So just saying words alone is not automatically an arrestable offense. So if a police officer is not engaged in executing process on a person, does not legally detain that person, or has not asked the person for assistance with an ongoing emergency that presents a serious threat of imminent harm to person or property, the person's word alone can rarely, if ever, rise to a level of obstruction, right? And that's because, again, freedom of speech, First Amendment. The fact that the incident may have attracted the attention of onlookers without more is insufficient to support a charge of disorderly conduct. The record facts in CW's case do not support a finding of disorderly conduct or obstruction of legal duty. If an arrest is not lawful, then a defendant cannot be guilty of resisting it. The common law rule still remains that a person may lawfully resist an illegal arrest without using any force or violence. We therefore reverse the order denying CW's motion for judgment of dismissal and remand with instructions to dismiss the adjudication delinquency and to correct the juvenile's post-adjudication records accordingly. So at this point, we kind of got a sense of this Florida common law rules, that has basically just enshrined what should be freedom of speech and the right to be left alone, which the right to be left alone, the privacy thing in Florida, to be let alone from government is a thing in the Florida Constitution. So, takeaway here that, is just really just to think about in the narrow situation is that if an officer is trying to arrest somebody and it's unlawful, they don't have probable cause, they don't have a reason to detain somebody, they can't then go and say, oh, well, because you said words or because you walked away, then that's obstruction. And we get to charge you, for resisting arrest without violence. It's just completely absurd and would be unlawful and be infringement on a person's First Amendment right to protest and their bodily property right and the Fourth Amendment to be free of unreasonable search and seizures. So, just keep that in mind. It's a narrow thing. If there's a lawful arrest, that's a whole different ball game. And if you have a lawful arrest, then you cannot resist that one, with the violence or obstruct it if it's a lawful arrest, of course. And if it is an unlawful arrest, it also, means that you can't do violence either. So that's kind of this exception, right? Non-violent resistance, words or protests or walking away or potentially running away. If it's truly unlawful, that's considered okay and protected. But if it's an unlawful arrest, you can't then go and start fighting and shooting up, the scene without potentially then getting charged yourself. So that's a really tough one in Florida to swallow, that police officers can get away with making an arrest of someone unlawfully and you can't violently stop that. You kind of have to, catch the ride and then beat the rap afterward. But it is an important distinction. So, obviously, if you have a situation, you should definitely talk with your attorney and discuss that and think through your specific situations of where you might fall in this. But otherwise, everyone should have that right to be able to protest an unlawful arrest at a bare minimum and to walk away if an officer is literally trying to arrest you for something. They have no reason to stop you, no reason to detain you, no probable cause for arrest. You should be able to just walk away. And if an officer arrests you, well, you might have to just go along with that and just say, I don't agree with this and I'm remaining silent. I don't consent to searches, but you'll have to fight it later and then, possibly do a lawsuit, a federal lawsuit, maybe a 1983 suit, to get yourself rectified for your violations of your constitutional rights. Well, I really appreciate, people hanging out for this. It's a first time that I've done this live stream thing. So I'm kind of excited about this. And we do have one person in the comments says, Bill says, and they put a cap on how much they have to pay for violating rights. That doesn't seem right. Yeah, I know, right? Sometimes they'll try to, they'll push for sovereign immunity. They'll try to keep you from being able to get any justice. They'll do everything they can to try to, fight back with you. But the key is just to work with your attorney. Don't say anything. Don't talk to police. Be vigilant and be diligent, with record keeping and make yourself in your best position to have a case against the officers who clearly violated your rights. And that's, how you have your best shot at potentially overcoming any qualified immunity claims or this or that, especially where it's a very clear fundamental right, something that's, explicit with like First Amendment things, that kind of thing. That tends to be a little bit easier to overcome when officers violate those real core fundamental rights that have strict scrutiny. So, All right. Thanks so much, everybody, for hanging out. And for those of you, watching afterward. And if you're new to this channel, please subscribe, get the notification bell. I would love to do this more, to go over cases and to kind of help highlight some really intriguing parts of Florida law, especially as pertains to fundamental rights. And you being here, subscribing, joining in the comments too, especially like Bill did, is very encouraging. So I really appreciate that. And I'll talk to you all soon. And in the meantime, enjoy the rest of the content that we have on the channel. Take care, everybody.